All right, Mr. Allen, it appears to me that you have reviewed the written paperwork with respect to your Arguello advisement. Although I do have some concerns about the way in which the form has been filled out, and you have not signed this document. So I am going to go through this with you orally.
But when you use the word "I understand," I will not understand anything. You have to use comprehend. I will not stand underneath you.
Before we go any further, let's set the stage here, because this is one of those courtroom moments where confidence wildly outpaces competence. What you're about to see is a classic sovereign citizen-style performance, where a defendant believes wordplay, semantics, and internet law forums somehow override centuries of legal precedent. This isn't just about refusing a lawyer. It's about someone trying to derail the entire judicial process by redefining basic English. The judge is methodical, patient, and clearly aware of where this is heading, while the defendant is already locked into a script he believes gives him power. Watch closely how every simple yes or no question turns into a philosophical detour, how understand becomes a battlefield, and how this obsession with language ultimately works against him. The real tension here isn't whether he gets a lawyer. It's whether the court can even establish that he's capable of knowingly making that choice. And trust me, the outcome is not going to go the way he thinks it will.
Well, that's not what the word understand means.
That says in law.
So I'm going to make the following advisement to you. Before accepting your decision to waive representation by counsel and letting you proceed pro se or representing yourself, I'm required to advise you of the following effects and consequences related to your decisions. A criminally accused enjoys the constitutional right of self-representation under the United States Constitution. The right of self-representation is personal to the defendant, and it may not be abridged by compelling a defendant to accept a lawyer when he desires to represent himself. Do you understand and acknowledge that?
Like again, I will not say I understand anything. I comprehend, but I'm doing this in Broomfield, so I'm doing the same case in Broomfield, same thing. So if that's anything better, I'm already pro se there, so we can save a little bit of time. I don't understand. I do comprehend what you guys are saying, what everything I understand, but I don't stand under you.
Again, that is not what the word understand means.
Maybe
I'm asking if you understand the information, comprehend and understand.
I comprehend, but I do not understand.
All right. Do you comprehend and understand that you have the right to be represented by counsel throughout these pleadings?
Yes.
Do you comprehend and understand that if you cannot afford an attorney, one will be appointed for you and will be provided to you free of charge?
Yeah, sure.
Do you comprehend and understand that I will appoint counsel if you want an attorney to represent you?
I comprehend, but I don't want no attorney from you guys to represent me at all.
Do you understand that the charge that has been filed against you is count 1, unlawful possession of a controlled substance under 18-403.512A under the Colorado Revised Statutes? That is a class 4 drug felony.
No, I don't understand, but I comprehend what you're saying.
Do you understand that this count carries a possible penalty of 6 months to 1 year in the Department of Corrections?
I comprehend. I don't understand.
How far have you gone in school?
Far enough to know that I've got my associate's degree, but far enough in this law. I've been doing this for a long time, so it's all right.
Are you under the influence of any drug, medication, or alcohol?
No.
Is there any reason that you do not understand today's proceedings?
I understand everything, but I don't comprehend. I comprehend. I don't understand anything. Today's hearing, I mean, can we go on the record?
We are on the record.
Then I can ask my questions also?
I need to go through this advisement first. Do you understand that I will allow you to consult with the public defender before you make a decision to waive counsel and represent yourself?
Yeah, no, thank you.
Do you understand that criminal law is very complicated and that an attorney trained in criminal law could be of great help in preparing and presenting your defense?
I comprehend and I read Braille.
This right here is where the sovereign citizen playbook fully reveals itself. The whole I don't understand, I comprehend routine is not clever, it's scripted. This argument is built on the false idea that the word understand legally means to stand under authority, which courts have rejected over and over again. The judge isn't confused and neither is the record. She's using understand in its plain English meaning, which is exactly how the law interprets it. What's important to notice is that every time the judge offers clarity, the defendant pivots, not because he doesn't grasp what's being said, but because refusing to acknowledge understanding is his way of trying to avoid consequences. Ironically, this strategy ends up doing the opposite. It raises serious concerns about whether he's competent to waive counsel at all.
You'll see my motions next week. I already have them done. I just didn't print them out today.
Do you understand and comprehend that you have a right to represent yourself, but by doing so, you take a great risk of not properly presenting your case?
I comprehend and I will represent myself just fine. Thank you.
Do you comprehend and understand that you have a right to remain silent and that anything you say can be used against you in court?
I comprehend. I do not understand. Again,
Do you comprehend and understand that you have a right to confront witnesses against you and to cross-examine them?
I comprehend. I do not understand.
Do you comprehend and understand that you have a right to have witnesses you choose called to and compelled to testify and appear before the court and testify on your behalf?
Comprehend again. I do not understand.
Do you comprehend and understand that the court may, but is not required to appoint advisory counsel to assist you in the preparation of your case?
I comprehend. I don't understand.
Knowing about your right to assistance of counsel and knowing the disadvantages of proceeding without counsel, is it still your desire to represent yourself in these proceedings?
You mean the advantages that I have? Not disadvantage? It'd be an advantage that I would have, not a disadvantage. I comprehend.
Is your decision to represent yourself made of your own free will?
Of course.
Is that what you want to do?
That's what I'm doing.
Do you understand and comprehend that if you waive the right to counsel, you will still be bound by all the normal rules of procedure and evidence, and that counsel would be familiar with these rules?
I comprehend. I do not understand.
Do you understand that there are possible defenses to these charges which counsel might be aware of, and if these defenses are not raised at trial, they will be lost permanently?
I don't understand what you just said because you didn't comprehend. I don't comprehend it.
Do you understand that in addition to defenses, that a defendant has many rights that if not timely asserted may be lost permanently, and that if errors occur and are not timely objected to or otherwise timely raised by the defendant, those errors may be lost permanently?
Again, I comprehend. I don't understand.
I'm also going to make the further advisement of you of the advantages of representation by legal counsel. Trained legal counsel is familiar with the following procedures: pretrial motions, including motions to suppress evidence, challenges to bills of information or indictment, protecting the right to speedy trial, selecting a jury, cross-examining all witnesses that may be called to testify against you, challenging the admissibility of any evidence presented against you, calling witnesses and presenting evidence in your behalf, arguing the facts and evidence to the jury in your behalf, arguing the law and evidence to the judge. In addition, trained counsel is familiar that in the event of conviction, filing, presenting, and arguing motions for new trial and/or arrest of judgment. Further, in the event of a conviction, trained counsel is able to argue the circumstances, facts, and law, and present witnesses to try to mitigate the sentence that will be imposed. Do you understand and comprehend these advantages of having trained legal counsel?
I comprehend. I do not understand anything.
This moment is where overconfidence really starts to become dangerous. The judge is clearly explaining, very patiently, that criminal law is complex, procedural, and unforgiving. She's not insulting him, she's warning him. And yet his response is essentially, I read. That's it. No acknowledgement of rules of evidence, no understanding of procedural traps, no awareness of how fast rights can be permanently lost. Courts don't require defendants to be smart, but they do require them to be realistic. And what's happening here is the judge documenting, step by step, that this defendant is brushing off serious risks with casual arrogance. Every one of these answers is being preserved for the record, and whether he realizes it or not, he's building the very case against his own request.
I'm also advising you that if and when errors occur during the trial, the right to appeal based on these errors is permanently lost unless you object to these errors in an appropriate time. Do you understand that?
I comprehend.
Your Honor, I am just a little concerned about the record, and I am wondering if, based on People v. Romero, the court wants me to do a Control F through this advisements of right to counsel and replace the words understand with knowing and intelligently, so that we can have a clear record on if he truly is understanding and comprehending what is going on, if he is just refusing to appropriately comply with the process that we are trying to have, if there is a competency issue,
I object.
and
You
if
don't
he
even have
can
jurisdiction
truly
over this.
go forward without the public defender. Because I don't think we can get the public defender off the case if he's not truly waiving the right. And I'm worried about how we're progressing here.
Well, I'm going to finish the advisement.
Okay.
Thank you for that, Ms. Staub. Mr. Allen, do you comprehend and understand that you will be precluded or prevented from asserting the ineffective assistance of counsel concerning all proceedings in which you represent yourself?
Comprehend.
Have there been any other threats or promises that have induced or caused you to waive your right to counsel?
It's a joke. Public defenders are jokes.
All right. All right. Any additional information you want to provide me with respect to your request to proceed without counsel?
Any what was that? Could you repeat that?
Is there any other additional information you want to provide me?
Well, I'd like to, on the record, we'd like to know who the injured party is. And where the verified criminal complaint is. And if the district attorney is willing to go and underneath penalty of perjury and sign one, then I'll go ahead and proceed with all this stuff. If not, because I require the fiduciary to state its trust, or show its trust and state its claim.
All right. Anything else you want to advise me?
Jurisdiction.
All right. And Ms. Staub, what was the case you cited?
Your Honor, it's in paragraph 1 of the
Oh.
right to counsel People v. Romero.
Got it.
690. Yeah, thank you. It's a good little cheat. Your Honor, People v. Romero has the record show that the defendant's decision to represent himself was knowing and intelligently made and was a product of his voluntary choice. So that's the test it refers to.
I just need a verified criminal complaint from you and I'll be happy.
Listen carefully to what's happening now. The judge is outlining constitutional rights, silence, confrontation, witnesses, and the defendant keeps responding with the same contradiction. I comprehend, I don't understand. That's not a legal distinction. It's a refusal to engage honestly with the process. And courts don't play word games when constitutional rights are on the line. Waiving counsel isn't symbolic, it's binding. The judge is essentially asking, do you grasp that once you do this, you're on your own? And his answers suggest not independence, but defiance. This is where judges start thinking less about autonomy and more about protection. Because allowing someone to represent themselves when they clearly don't appreciate the consequences can invalidate the entire proceeding later.
All right. In order for the court to accept the defendant's waiver of the right to counsel, in order for the court to accept that waiver, the court has to be in a position to make a finding that that waiver is voluntary, knowing, and intelligent. Based on the record that has been made today, I'm unable to make that finding. Therefore, at this stage, I cannot release the Office of Public Defender.
Then
I do find.
I object to that because there's nothing I want from the public defender. They're paid by you guys and that's how it is. I don't want nothing to do with the state. I'm not contracted by the state.
Ms. Kleiman Moran, is there something you want to address to the court? I saw you rise.
No, because we weren't taken off, I was ready to make a record. Just
I don't want on my record.
I understand all of that. But at this point, I'm not going to remove the office
I'll
of public
follow my
defender.
paperwork I need to file, and you'll see I'm very much comprehending all this BS that's going on here.
And what I'm saying is that based on the record that we've just made, including my understanding of the difficulties you had understanding the questions that I was asking you, I'm unable to make that finding. So I'm not going to accept your waiver. I do not find that it is knowing,
So,
intelligent, or voluntary.
How is it that every other courthouse does accept everything that I say? Because I know more than what they probably do. I've been doing this for so many years, been in and out of this trouble for so long. You got to know this shit. So I mean, comprehend. Just get into the verified criminal complaint, or have the DA sign one, and I'll go forward with this. And I don't want the public defender to speak on anything on my case. That they will not speak on anything. They didn't want to do what I wanted to do the first time. They ain't gonna do it the second time. They don't want to file the paperwork I want to file. It's done. I mean, I don't need them. I can file the paperwork myself.
Ms. Clymer-Moran.
I don't even know who that woman is. She won't speak on my behalf or anything, or not even on my state.
I
Judge,
understand.
I am covering for Miss Landry.
Mhm.
Miss Landry is on the record next door.
Yeah.
My understanding is we have been appointed and we will continue to represent Mr. Allen until we have been withdrawn. I think this would
You need
be
to
better
withdraw.
handled.
I object to this. I object all the way.
I think it would make sense to reset for Miss Landry to be present.
Okay, I'm willing to do that. Because again, as we are here today, I can't make the necessary findings.
Well,
So
I'll file my paperwork today, and you'll have it by tomorrow.
I will set this for an arraignment.
I don't have Miss Landry's calendar, but I think setting this sooner rather than later would make sense.
I can set it for Friday, January 16th at 8:30 a.m.
Can't do it. Got court,
Where do you have court?
Broomfield. Or do you think it's Denver? One of the two. No, not Denver. Adams County. I have a lot of court cases coming out in Adams County.
This is one of the most important warnings any judge can give, and it's often the one pro-se defendants ignore the most. Being bound by the rules of procedure and evidence means no shortcuts, no excuses, no leniency because you're not a lawyer. You don't get extra time, you don't get help objecting, and you don't get to fix mistakes later. When the judge explains that unraised defenses and missed objections can be lost permanently, she's not exaggerating. That's black-letter law. And the defendant's response? More semantics. More deflection. What the court is seeing is not a strategic choice, but someone who fundamentally misunderstands the stakes while insisting he understands everything.
Looks like February 5th or 5th, 6th is all right. 6th is fine, not the 5th. I have trial then. I have trial all coming up. By myself.
All right, let's set, how about February 12th?
February 12th.
Let me just double check our shared calendar. That should be fine.
It should be fine.
All right, February 12th at 8:30 a.m. for a continued arraignment.
Yes.
Thank you. All right, Mr. Allen, your bond is continued. You're required to be back here in person, February 12th at 8:30 a.m. If you're not here, I have to issue a warrant for your arrest.
And on the pretrial, do I go to the pretrial day, or is they're still open?
You can.
And you said, when do I get off that? It's been more than 90 days.
Uh,
I'll talk to Jordan about it. She'll. I gotta talk to
They've
her.
asked that you remain on enhanced supervision.
So that's an illegal sentence also.
And here it is, the greatest hits package of sovereign citizen talking points. Who is the injured party? Where is the verified complaint? Jurisdiction. These phrases are designed to sound legally sophisticated while actually being legally meaningless in this context. Criminal cases don't require a personal injured party the way civil cases do, and charging documents are governed by statute, not personal approval from the defendant. The judge doesn't argue with him here because she doesn't need to. These arguments have failed thousands of times before, and raising them doesn't strengthen his position, it weakens it. What it does do, however, is further demonstrate that he's not engaging with reality as the law defines it.
Court calls 23T11796, 24M5950, 25M4266, and 25T7853. Isaac Allen.
Good morning, Your Honor.
Good morning, Mr. Allen.
Sorry about me being late.
You're good.
Car troubles.
You're good. All right, we're set for status conferences in 23T11796. Court calls 23T11796, 25M4266, and 25T7853 Isaac Allen. All right, so for the record, the court also calls 25T112597. All right, so Mr. Allen, I'm looking at the roll 11 for 25T11796. I understand that in that case, sir, you wish to enter a plea to too fast for conditions. Is that correct?
I will say yes, I do.
All right. You understand the maximum penalties for this charge is a $100 fine and 3 points on your license?
I do.
And looking at the Rule 11, sir, I see your signature on this document. Did you have sufficient time to go over this Rule 11 in its entirety?
I did.
Do you have any questions about your rights?
So I comprehend it very well.
Has anyone promised you anything in order to enter this plea?
No,
Anyone forcing you or threatening you to enter this plea?
absolutely not.
Are you under the influence of any alcohol, drugs, medication preventing you from entering this plea?
Absolutely not.
And this is the charge of too fast for conditions. How do you plead?
I plead guilty, Your Honor.
Guilty or not guilty?
I plead guilty.
I'll accept the guilty plea, find it to be entered into knowingly, intelligently, and voluntarily after a full advisement of rights and consequences by the court. Mr. Houseman.
Thank you, Judge. Judge, I'm asking the court to impose an appropriate fine on the too fast for conditions plea. I'm asking the court, as I noted on the paperwork, 25T12597, I believe, has an active warrant based off of failure to appear in the FAC last week. So we want to make sure that warrant's canceled as well, and then just have the court vacate any future court dates on these matters.
Mr. Allen, anything you want to tell me, sir?
Well, I was going to actually court in Denver that day, so I was kind of driving way too fast for conditions. I sped and I passed the officer, so I just pulled over automatically. I was going way too fast for conditions.
All right.
I no longer have that vehicle no more. It's a Saab. It's no longer here. I don't have a fast car no more. I have a slow truck, so
Okay.
there's no more speeding.
Understood. Here, the court will impose a $15 fine. Pursuant to the plea here, all other cases are dismissed. We will make sure that all cases are closed and any bench warrant is quashed.
And all the bonds be returned?
They should be, yes, sir.
Okay.
We'll have some paperwork for you shortly, Mr. Allen. Good luck, sir.
Thank you.
Yeah, he's gonna need that luck in his other case, where he doesn't understand anything about what's going on.
When you exit your cruiser, where do you go?
I go to the driver's side door.
And who do you, is there a person sitting in the driver's seat?
Yes,
Do you recognize that person from the driver's seat in the courtroom today?
I do.
Could you please point them out by describing an article of clothing they are wearing?
Mr. Flores is sitting to my right wearing a brown shirt.
Your Honor, may the record reflect the witness has identified the defendant subject to cross.
It shows subject to cross, sorry.
And officer, were you able to recognize the defendant as Joseph Flores from prior experience?
Yes,
And upon contacting the defendant, what did you do?
I asked Mr. Flores to exit the vehicle.
What was his response to that request?
He responded that he was not going to.
Sergeant, we've discussed dash camera. Are you familiar also with body worn camera?
Yes,
How are you familiar with that?
for similar reasons.
Were you wearing body worn camera on January 16th of 2025?
Yes, ma'am.
Was it on and recording?
Yes,
I'm willing to stipulate to the foundation.
Oh, okay, thank you.
I've submitted in and be playing some clips as well.
Understood. So with that in mind, the people would move to admit this as exhibit number 2, Your Honor.
All right, exhibit 2 will be admitted.
For the record, I'm playing at 2 minutes and 7 seconds.
Hey, go ahead and step out of the car for me, Joe. Get out of the car, please.
No, I'm not.
Get out of the car, please.
I'm not stepping out.
Get out of the car, Joe.
I'm not stepping out.
I'm pausing at 2 minutes and 19 seconds. Sergeant, can you explain why you felt it necessary to ask the defendant to get out of the car?
for officer safety concerns.